Today I'd like to talk about the oral arguments with respect to Proposition 8 and DOMA that took place on Tuesday and Wednesday. And obviously a lot of ink has been spilled about the oral arguments that took place before the Supreme Court. And I'm not going to rehash much of that because that's not the point of this vlog. But I would like to extract three little nuggets, three takeaways of mine from the oral arguments. The first one involves an exchange that took place between Chief Justice John Roberts and Ted Olson on Tuesday. Ted Olson being one of the lawyers on behalf of marriage equality. Chief Justice Roberts seemed to take the position that what the marriage equality proponents were after was basically just a label change. He sort of trivialized it, that you just want to change the label. And he seemed to feel that it was an improper label change to call gay marriage marriage. And he exemplified that with an analogy that I'd like to read to you. Here's Judge Roberts. If you tell a child that somebody has to be their friend, I suppose you can force the child to say, "This is my friend," but it changes the definition of what it means to be a friend. So there you have his point of view in a nutshell, that this would be forcing people to call something that isn't marriage, marriage. And I think this is a really interesting analogy because I think that Justice Roberts has it 180 degrees wrong. And I'd like to replace his analogy with an analogy of my own. Suppose in the days of the segregated South, an African American woman goes over to a white house to clean their house. She goes there every day. And because she doesn't have child care, she takes her 4-year-old kid with her. Well, over time, that 4-year-old kid begins to play with the white 4-year-old kid from the household. They enjoy each other's company, they like the same games, they look forward to playing together every day, and so it goes. Well, one day, a neighbor looks over and sees them playing together and runs over there with a concerned look on her face and says, "Why are you playing with this boy?" The white kid says, "He's my friend." Well, the kid's mother overhears this, pulls the kid away and says, "No, they're not friends. This other kid is simply the child of the maid. They're not friends." Well, of course they were friends. They had everything that constitutes a friendship. Shared interests, fondness for one another, anticipation of meeting together, enjoyment. By any common sense definition of friendship, those are friends. Now you can change the label on that if you want because of fear or animus or concern about the opinion of others, or simply a desire to confer a lesser status on the relationship. You can say they're acquaintances, you can call it something other than friendship, but the underlying reality is that they're friends. Well, so it is in California. All those people who live in unions in California, by any normal definition of marriage, are married. Now, through fear or social disapproval or the desire to confer inferiority upon their relationship, you can call it something else. But the underlying reality is that those are marriages, which is exactly what the Ninth Circuit found when it ruled that Prop 8 did nothing other than confer a status of inferiority upon those relationships. So I think Roberts got it completely wrong, but his analogy was helpful for how wrong it was. Now, another exchange I'd like to address also involved Ted Olson, this time with Justice Scalia. And I actually think Scalia has a good point in this exchange. Scalia asks Ted Olson, and I'm going to quote here, "I'm curious, when did it become unconstitutional to exclude homosexual couples from marriage? 1791? 1868, when the 14th Amendment was adopted?" So he wants Ted Olson to give him a date at which time it became unconstitutional to ban gay marriage. And I thought that Ted Olson was going to rise to the occasion and say, well, one could argue that it's been unconstitutional ever since the ratification of the Bill of Rights in 1791, or at least say that once the Equal Protection Clause was adopted in 1868, that gay marriage, that banning gay marriage was unconstitutional. But Ted Olson refused to answer the question, and I think he was wrong. I think if you have a theory of a law being unconstitutional, you ought to be able to say not only which provision of the Constitution it violates, but also you ought to be able to put a time on that. And Scalia took that position. Olson answers Scalia's question with a question of his own. He says, when did it become unconstitutional to prohibit interracial marriages? When did it become unconstitutional to assign children to separate schools? Well, Scalia, I thought, had a good answer. He says, well, that's an easy question. At the time of the Equal Protection Clause. That's absolutely true. So I don't know why Ted Olson didn't have the courage of his convictions and actually say, well, because we're claiming this is a violation of equal protection, clearly, since the time of the Equal Protection Clause, this has been unconstitutional. But he seemed to sort of waffle at that point. And I'm not sure he would have waffled had somebody asked him, when did the doctrine of separate but equal become unconstitutional? He would have said, at the time of the adoption of the Equal Protection Clause. So I'd just like to have seen a more robust response to the question posed by Scalia. Finally, I'd like to say a word about the DOMA oral arguments that took place yesterday. A lot of the very knowledgeable, very insightful, very thoughtful commentators came out of those oral arguments with the view that DOMA's days are numbered, that within several months' time, when the ruling comes out, DOMA is going to be overturned. And I certainly think from a policy standpoint that would be a great thing if DOMA were overturned. I just didn't emerge from the oral arguments quite as sanguine as some of the commentators did, because I really think there is a legitimate question of standing here. That is, whether the Supreme Court has the authority to take this case in the first place. And let me just say why quickly. Edie Windsor suffers a loss because the federal government does not recognize her marriage. When her spouse dies, the IRS does not give them the favorable tax treatment that they would a married couple. And the result is that Edie Windsor owed the IRS $360,000 in estate taxes. So she suffers an injury, takes it to court. The first court rules that, yes, you have a legitimate marriage as determined by the state of New York, where you live, but because of the Defense of Marriage Act, the federal government cannot acknowledge your marriage, and you are forced to pay the $360,000 in estate taxes. She appeals that to the Second Circuit Appeals Court, and the Appeals Court overturns this and says DOMA is unconstitutional. Well, that's a good ruling for Edie Windsor. And at the time of that ruling, the government had changed its position and said, we agree with this. We agree that DOMA is unconstitutional and that we should pay her, refund her the $360,000. But then the government does something that was interesting. It appeals the decision. Now, based on the oral arguments yesterday, not only is it highly unusual to appeal a decision when you're in agreement with that decision, it's highly questionable whether you can appeal a decision where you side with the decision. So the government is not only appealing a decision that it agreed with in the first place, it is not defending the DOMA law, at which point a group of House Republicans jump in and say, well, if the government isn't going to defend this law, we'll defend it because we believe in it, even if the government doesn't. It's not clear that they have any standing because they hadn't suffered any particular injury. So I think that there were a number of issues raised about standing, which will give the Supreme Court cover to not rule on the merits. I think if they do rule on the merits, I agree with all the commentators that DOMA is going to get thrown out. But whether they actually get to that point, I'm not so sure about. I'm Jeff Rowan. I'll see you next time.